everyone. Welcome, welcome. Can I have your attention, please? This is sort of like law school class. Everybody's in the back, and we have a whole gap in the front, in the middle here. For those of you who don't know, I'm Elena Langen, the Dean of the Law School. Thank you all for being here. This is always one of our signature events. For the fall semester, this is the 40th anniversary of the Bainbridge competition, and it always brings together our upper class, excellent orators who will practice their appellate advocacy skills, and then we finally narrow it down to two. And we have two finalists today, Joseph Merlino, who is in our Flex program, and Samantha Schneider, who is in our full-time program. So Samantha and Joseph have gone through rigorous competitions up to this point and were ultimately selected as the finalists after very, very tight rounds, I understand. We're very fortunate that we also get the support from the legal community to act as judges. So we have Judge Crecca, who you will have an opportunity to meet, and some of you may have already met him previously. He is the administrative judge at the courthouse right across the street. And we also have the past president of the Nassau County Bar Association, who happens to be a proud Toro alum. And also we have the current president of the Suffolk County Bar, and you'll hear more about them from the Moot Court chairperson in just a minute. That's Cornell Baus. So we're very, very thankful that they have taken time out of their day to act as a very hot bench for our competitors. So I'm going to hand it over now to Laura Riano, who will tell you a little bit more about the judges and how the competition today will go. Thank you, Laura.
Thank you, Dean Langen. Good afternoon, everyone, and welcome to the 40th Annual John S. Bainbridge Moot Court Competition. As Dean Langen said, my name is Laura Riano. I'm the recruitment editor and alumni liaison for the Moot Court Honors Board. It is a pleasure to be here with all of you this evening and to present to you our two finalists, Joseph Merlino and Samantha Schneider. With the aid of our advisors, Extraordinary E-Board, and the Office of Administration, this event was made possible. We are honored to have our esteemed judges here with us this evening. The Honorable Andrew A. Crecca, District Administrative Judge for the Suffolk County, Mr. Dorian Glover, past President of the Nassau Bar Association, and Mr. Cornell V. Baus, President-elect of the Suffolk Bar Association, to help judge the competition. As most of you have seen in the program, this is a Second Amendment issue, and it's a very interesting topic. Without further ado, I present to you the final round of the Bainbridge Moot Court competition. Good luck to you both. Bailiff Travaglione, you may proceed.
All rise. Oyez, oyez, all persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Can we get appearances, please, first for the petitioner? Joseph Merlino, State of Pennsylvania. Good afternoon. And for the respondent. Clerk, want to call the case in?
The case of State of Torvenia versus Jenna Summers is now in session.
Very good. Counsel, you may proceed with your arguments.
Good afternoon, Mr. Chief Justice and your honors. May it please the court. My name is Joseph Merlino, and I am representing the petitioner in this matter. At this time, your honors, petitioner would like to request 1 minute for rebuttal.
So granted.
Thank you. This case is brought on appeal of the United States Court of Appeals for the 18th Circuit, holding local statute 20-23 to be unconstitutional. Respectfully, your honors, this case is about the lawful denial of respondent's application for a license to carry a firearm in accordance with the statute. Would Your Honors like a brief recitation of the facts?
No, I'm familiar with the facts. My brethren doesn't either. No.
The petitioner respectfully requests that this court reverse the decision of the Court of Appeals for the 18th Circuit because the statute is lawful for the following 3 reasons. First, this court has consistently held that the Second Amendment is not an unlimited right. Second, as a structure that is owned and operated by the government, the ferry falls into the long-respected category as a sensitive location. And third, the police can better ensure public safety than firearm carrying civilians within the confines of this sensitive location. Now, per petitioner's first argument, the sole reason for the denial of the respondent's application relates to her insistence on carrying a gun in a sensitive location. And to this point, Your Honors, we look to 2 cases. In 2008, District of Columbia v. Heller, out of this court, twice mentioned that the Second Amendment is not an unlimited right, particularly to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. Further, in 2010, this court held in McDonald v. City of Chicago that no fundamental right is absolute. And I quote, "The state can limit so long it's not eliminating a certain right in the effort to devise."
If I may, your 3 points, consistency, sensitivity, and police. Okay, consistently held. Everything's changed. Isn't that right?
Respectfully, in what regard, Your Honor?
Ruined?
So, petitioner does not necessarily agree that that's the case. So, as it pertains to...
Don't you think that Bruin has sort of changed the landscape? I mean, this court was fairly clear that this is not just any right. This is the equivalent of the rights afforded under the First Amendment.
Absolutely,
Given
Your
that, you're saying that it's not a limited right. Of course, it's not an unlimited right, but here, she's trying to defend herself and her family. And it's clear that, I think in Bruin we were clear too, that that right extends beyond the home and extends to public defense of lawful citizens. Lawful citizens can defend themselves. So how do you justify this restriction?
So, as decided in Bruin, this court held that we must look to history and tradition. And that tradition and history extends all the way back to England 1328 in the Statute of Northampton, which restricted firearm carry in the presence of government officials, justices, as well as on government property. Bruin also holds that the inquiry courts must conduct on such matters will often involve reasoning by analogy. And to this point, we look to the 10th and 4th Circuits. First, Beniti versus the United States Postal Service, 10th Circuit of 2015. In that case, the post office restricted firearm carry on its premises because it's a matter of doing business with the post office on its own property, and the regulation is directly relevant to the post office's objectives, which include providing a safe environment for its...
That was a post office, clearly a government building. Fits within what you've described as one of the places historically permitted as a sensitive location. This is a ferry, a mode of transport back and forth to bring her kids to see their father.
Right. So...
Don't you think that distinguishes it?
Your Honor, it's not just the ferry. Respectfully, it's also the station that's attached to it, the parking lot that's attached to it as well, all belonging to government property, which is well within...
She's looking to transport her children to see their father on a ferry. So speak to that point.
Your Honor, respectfully, take, for example, police officers who in some view have an extended right as far as the Second Amendment. They could pretty much go anywhere in this country with a firearm just by flashing their shield. However, they cannot frequent a bar where there's alcohol consumption with a firearm on their hip. And so the point there...
Answer the question, which is, how does a ferry qualify as a historically or traditionally regulated location?
It's akin to a government building, Your Honor, and then couple that with the fact...
That's a conclusive statement. We're asking for a description, okay? You're making an analogy that it is a government building, but this is a ferry. Okay, so by saying that it's akin to a government building doesn't answer the question for us. Okay?
Your Honor, this is government property, so in essence, a government building, and couple that with the facts that this ferry is a contained and highly congested vessel. As the record reflects on page 11, there's 700 patrons per trip, okay? And that nature of the ferry being congested and a contained moving vessel makes it highly sensitive.
Counselor, clearly, I know that you're trying to make an argument, and you're making a good argument. It's not a building. So you can't say it's a building. It's a boat, okay? It's a boat. Has a lot of people on the boat. And you mentioned the facts early on. Let's just go back to the facts and think about what brought us here, of the violence that Ms. Summers encountered early on, which brought her here. You think that would have happened in a post office? And then you also said, and just speak to these points, you also said that the police or the security, the armed security, are there to prevent that. They didn't prevent it. They didn't prevent it. So speak to that point. And at least for me, it's not don't call it a building, because it's not a building. It's a boat. Okay?
Well, respectfully, Your Honor, on the first point about the analogy with the ferry being a building, the main point there is that it's not just a boat that's part of this property. It's also the station, which is a government building. Now, to your question about the effectiveness of the police, as page 2 reflects, the event occurred as respondent was disembarking the ferry. As page 3 reflects, respondent believed she heard her screams were heard, but that's unsubstantiated. The record also reflects that police were present and are present at this ferry and station. However, the perpetrator was able to flee the scene. This leads the municipality to believe that this is a learning opportunity where we need to be more strategic with our police force. Rather than permitting mass carrying in this location, be strategic with our police footposts, particularly upon exiting the ferry.
So your answer to Ms. Somers is that, yeah, it was too bad for you on that particular day, but we're going to be better. Where her argument is, I would like to protect myself. And the Second Amendment says, I had that right.
So respectfully, Your Honor, with the analogy I created earlier about police carrying firearms, off-duty police, we all need to make choices. The respondent does not contend that, the petitioner does not contend that the respondent has a right to carry a firearm. The issue is the specific location, where those rights are necessarily restricted. And I'm sorry, I believe there was another question in there that escaped me.
Is it too bad for her? Doesn't she have the right to protect herself?
She does have a right, but not here. And as it pertains to your notion about too bad or what have you, this is an unfortunate reality of our system. It requires experiences to better policy and our statutes.
So, counsel, are you saying that the state government can regulate any location that they want?
No, absolutely not, Your Honor.
So that it comes back down to whether they can regulate this particular ferry?
Yes. Per petitioner's third point, as evidence in the record, Ms. Summers wants to carry a firearm in fear. Fear is quite possibly the worst determining factor in the decision to pull a trigger, particularly in this location. Further, it's undisputed that the government has an obligation to ensure public safety, and does so typically in two ways. First is utilizing modern technology to seize dangerous weapons upon entry of a government building, and the second being the use of police force. Police are trained not only on how to handle a firearm, but how to respond to such situations, particularly in crowded places. Under the ruling of the 18th Circuit Court of Appeals, there'll be no control of fear in dangerous situations because there will be no public deference to the police, rendering ineffective if police must deal with potentially hundreds of people carrying lethal weapons.
Counsel, do devices to scan for weapons on these ferries, do you know?
No, Your Honor, but that's why there is a police presence.
Continue.
So the illegal guns can get on the boat, but Ms. Somers, who wants to have a legal gun, she cannot get on the boat. I mean, that's basically what you're saying.
Ultimately, yes. There's ultimately a choice that we all need to make. And so if she wants to exercise her right to keep and bear arms, there are other means of getting to her ex-husband's home and transportating her children. And circling back to the second point, the U.S. v. Machinjaro case out of the Fourth Circuit also upheld conviction of possession of a loaded handgun in a motor vehicle in the parking lot of a national park in violation of a statute. And so the key point there, Your Honors, because that case has a close parallel with the Beniti case that I previously discussed, if parking lots can be deemed sensitive locations in connection with government property, then so should a highly concentrated public ferry. On the point of police, just to put a bow on that, petitioner respectfully urges this court to consider the impact this will have on policing, as well as the detrimental effects of the Court of Appeals ruling will have, pertaining to locations that historically and traditionally have common sense reasoning for the government to restrict firearm carry. In closing, Your Honors, this is simply a common sense policy, as we cannot permit opening the floodgates to mass lethal weapons carry in highly sensitive locations. Therefore, the petitioner respectfully requests that this court reverse the decision of the Court of Appeals for the 18th Circuit. Thank you.
Counsel, before you step away.
Yes.
So I just ask you, what standard should this court use in determining what is a sensitive location? Because I've heard many different things from you. Crowded areas should be sensitive locations.
Right.
So Manhattan's pretty crowded.
Respectfully, Your Honor, if alluding to Bruin, that case is vastly different as far as the analysis required. So in Bruin, the issue at bar there was New York's proper cause requirement, as well as restricting carry within the island of Manhattan, or New York State, really. And so that analysis is vastly inherently different versus what's required here, where we're talking about a specific location. Now,
what is the standard that we should use? Because Bruin really was about proper cause, and that being unconstitutional. It really wasn't about sensitive locations per se. So what do you propose our standard in determining what is and what is not a sensitive location be?
Certain factors that are...
What factors?
Police presence, the crowdedness of an area, government property as well, and potentially time, place, and manner as well.
Thank you.
So if it's a crowded McDonald's and there's a security guard, because it's not a great area, and he happens to be carrying a weapon, a lawful weapon, and he's in the corner, is that a sensitive location?
Your Honor, my time is up. May I briefly answer?
Yes. I'll give you permission to answer, sure.
So, yes, Your Honor, there should be carry permitted in that location because McDonald's is not a government location.
Okay, so it distinguishes itself because it's not a government entity.
Correct.
Okay.
Thank you. Thank you.
For the respondent, please.
Good afternoon, Mr. Chief Justice and Your Honors. May it please the Court. My name is Samantha Schneider, counsel for the respondent Jenna Somers. This case is about a single mother who is seeking to carry a weapon on board the Birmingham ferry in order to better defend herself and her children. This case is brought on appeal of the United States Court of Appeals for the 18th Circuit, which properly held that the Trevana State Criminal Code, Section 20-23, unconstitutionally infringes on Ms. Somers' Second Amendment right to keep and bear arms for the sole purpose of self-defense. this court should affirm the 18th Circuit and agree that Ms. Somers is exercising a recognized protected privilege that falls within the scope of the Second Amendment for 3 reasons. First, the Birmingham Ferry cannot properly be construed as a sensitive location due to the fact that there is no substantial analogous that have historically held this to be true. Second, the long-standing history of firearm regulation guarantees citizens the right to carry weapons in case of confrontation. And third, the Trevania State Criminal Code, Section 20-23, is overbroad and should not include a ferry boat as a sensitive location, especially in the case before this court where there is a clear need for self-defense evidenced by the record. As to respondent's first point, prior court precedent has never considered whether a ferry boat is a sensitive location, and doing so would violate the Second Amendment. In 2008, this court in the District of Columbia versus Heller held that the Second Amendment is a pre-existing historical right that empowers citizens to keep and bear arms. And here, Ms. Somers, as a law-abiding citizen, has that right.
Ms. Schneider, if I may, to your first point, the ferry not being sensitive, we had, from Mr. Merlino, the Chief Justice asked, since we had that question about it not being analogous with any prior precedent, what the standard would be. How would you answer that question?
Your Honor, we have the standard right now as any place that is overcrowded and there's police, but in the particular case, that didn't guarantee safety here. So we think we should look to factors as a means of escape. And here on a ferry, you are stuck in the Trevania River, and there's no means of escape.
Should we allow firearms, people to carry firearms on airplanes?
Your Honor, an airplane is drastically...
Means of escape there, right?
Your Honor, an airplane is drastically different because in an airplane, for number one, there's TSA pre-checks, there's metal detectors, and for another factor, you're strapped in. But on a ferry, you're allowed to walk around, you're allowed to congregate everywhere, and that could potentially pose a greater risk. Going back to respondent's first point, courts have not yet ruled as to whether a ferry boat's nature is sensitive as to bar a law-abiding individual the ability to exercise a deeply rooted constitutional right. Thus, the Birmingham Ferry cannot argue to be a sensitive location where there exists no historical precedent. Petitioner's argument is that they are basically permitted to arbitrarily ascertain a location as sensitive just to regulate firearm possession. By doing so, this gives legislatures more power than they are vested over citizens. In June of this year, this court in New York State Rifle and Pistol Association versus Bruin stated that there is no historical basis to effectively declare the island of Manhattan a sensitive place simply because it is crowded and protected generally by the police. And as the record reflects on page 2, petitioners argue that Trevania legislatures, by drafting Section 20-23, intended for the Birmingham Ferry to be a sensitive location because it's owned, operated, and under the control of the state of Trevania, which has armed state police officers aboard all their vessels and at their ports. However, as the record reflects on page 2, Ms. Somers was assaulted in front of her 2 twin 6-year-old daughters who had to witness something so traumatizing, and there were no police around to protect her. Therefore, the ferry cannot be deemed a sensitive location simply because there are police officers on board. Their presence alone does not guarantee safety.
The statute, correct me if I'm wrong, says that it's a vehicle under the control of government, federal, state, or local government, public transportation, basically. So in this case, isn't that narrowing it down?
Your Honor, respondents would argue that we would think that all public transportation, if it meets the criteria, should be not deemed a sensitive location. As to respondent's second point, the long-standing history of firearm regulation guarantees citizens the right to carry weapons for the use of self-defense as established under the scope of the Second Amendment. In 2012, the Seventh Circuit in Moore v. Madigan held that the Second Amendment grants the right to carry weapons for the sole purpose of self-defense, and they recognized that that is vital just as much as outside of the home as it is within. Page 2 of the record reflects that Ms. Somers was riding the Birmingham ferry. She was approached by a man who demanded all of their belongings, and in an effort to defend herself, she was stabbed in the shoulder, and the man was able to escape.
Snyder, if I may, can you speak to Mr. Merlino's point regarding the armed guards in the sense that perhaps better training would be advantageous in this situation as opposed to allowing the community to carry guns?
Your Honor, police officers cannot be everywhere at once. Respondents argue that. And here, at the end of the day, we have a constitutional right to keep and bear arms for the sole purpose of self-defense. And that alone is not the better solution here because their presence isn't guaranteeing anything, and we shouldn't rely on them as the only source of protection. Per respondent's second point, this would show that there is a real necessity for self-defense on the Birmingham ferry to prevent situations like this from happening again.
Counsel, I don't think this court, we recently ruled in Bruin that that right to carry goes well beyond the home, and the right that citizens have an absolute right incorporated to the states to carry. So I don't think you're going to get pushback from us on that since it's such a recent ruling. What is your next point?
As to respondents' third point, well, I would like to point to 2015, the 10th Circuit in Bonity versus United States Postal Service. They held that the regulation prohibiting the carrying of firearms on USPS property, including the parking lot, was constitutional. Here, however, as indicated on page 4, and previously mentioned, an average of 365 assaults occur per year on the Birmingham ferry, which shows that Ms. Somers is more likely to be a victim of another assault on a ferry than a person would be in the parking lot of a USPS property. In addition, it's easier, as mentioned before, for someone to run away from a possible assailant in a parking lot than they would be on a ferry where they are stuck in the middle of the ocean. And furthermore, a parking lot is drastically different from a ferry when looking at it through a timeline of possession. In Bonity, point A being someone's home. As Heller stated, we are allowed to carry our weapons. Point B being the parking lot, where petitioners argue that we are not allowed to carry, and point C being the USPS building, where we are also not allowed to carry. In Bonity, the 10th Circuit held that points B and C were within the state's authority to regulate firearms. And this differs in that a person knows for an absolute fact that he or she may not possess firearms when going to the USPS and the parking lot attached thereto.
Well, if I may, wasn't that Mr. Merlino's point regarding the government building, that this is a governmental building, so therefore there would be that knowledge that you're not to carry in this space? I mean, he vociferously argued that this should be so, and sounds as if you're saying that there a chance that a ferry may be analogous to a governmental building?
No, Your Honor. Respondents are arguing that it's not. It is not a government building, and as you mentioned before in petitioner's argument, this is a ferry boat. This is meant for transportation. It has nothing to do with the building. And going back to respondent's second point.
So what's the standard? How do we determine what is and isn't a sensitive location?
Your Honor, we should look to factors as the means of escape, because here there is no means of escape. In a building or in a typical sensitive place like a school, they have procedures. Usually in a school you have to state the reason as to why you want to enter before you can.
You addressed this earlier, and the Chief Justice mentioned an airplane, and your modification of that was, alarms at the, security checks and TSA and the like. So how are we going to minimize this right of escape? Because you minimized it by saying an airplane is not such. Well, where does this end, this right of escape?
Your Honor, we can't implement factors like metal detectors here because it's not practical. It's not efficient. Ferry boats were meant for fast transportation. So the only resolution here for law-abiding individuals who want to exercise their Second Amendment right is to keep and bear arms for the sole purpose of self-defense. And if a law-abiding individual feels as though the ferry boat is a violent place, they should be able to exercise that right.
Counsel, can you tell me the difference between having people on board this vessel that are untrained, not as trained, and probably untrained to use a weapon, as opposed to the ones that are armed and trained to use a weapon?
Your Honor, respondents argued that there's a risk with anything. And we would make sure, we still want people to, law-abiding individuals, to meet certain licensing requirements, clean records, background checks, proper training. And as you mentioned before in petitioner's argument, people do they bring guns illegally onto ferries, and that's all the more reason as to why law-abiding individuals should be able to do so.
So in other words, in order to cure that problem, we bring more guns onto the boat. That's basically what you're saying?
Well, Your Honor, this question was actually raised in Bruin, whereby Justice Kavanaugh dismissed the state's argument because they failed to show that accidents happen on a substantial level. And Justice Kagan also elaborated that there were no constitutional rights that operate in this context, and we should not do that here. As to respondent's third point, Section 20-23 of the Trevania State Criminal Code is overbroad, and when applied to the instant matter, it violates her Second Amendment right to keep and bear arms. In 2022, the New York State Rifle and Pistol Association versus Bruin.
I think your right of escape is overbroad. What do you say to that?
Your Honor, respectfully, respondents don't agree with that because, as mentioned before, other typical sensitive locations have procedures in place and things that we can do to prevent when situations like this that happen to Ms. Sommers, to protect yourself. But here, if someone, a law-abiding individual or anyone really, is stuck in the middle of the ferry, how are they supposed to protect themselves when they're solely relying on the police? And even further, the record indicates on page 3 that 700 passengers are on this ferry. How are police officers supposed to get to someone, let's just say, in the back of the boat that's being assaulted? There's no means of protection. People have the Second Amendment rights, or enumerated right, to keep and bear arms.
So you're arguing that the statute's overly broad. That's what I heard you say.
Yes, Your Honor.
I'm looking at it, and there are 5 categories here. So how is it specifically, how is it overbroad? It says schools, school buses, government buildings, court buildings or offices, aircrafts or airports, and then specifically vehicles under the control of federal, state, public transportation. It's pretty easy to define.
Your Honor, respondents are only arguing that Section E is overbroad. For any vehicle owned or under the control of federal, state, or local government. Just that section is what we are arguing. The rest we find is constitutional.
Specifically, why is that overbroad? It's pretty specific, isn't it?
Your Honor, respondents are arguing that that is not specific and we shouldn't deem a public transportation just in general a sensitive location. Per respondent's third point. In 2022, the New York State Rifle and Pistol Association versus Bruin stated that expanding the category of sensitive places where there is public congregation and they are not isolated from law enforcement defines that category far too broadly. And as the record reflects on page 4 and previously mentioned, the Trevania State Criminal Code is overly restricting and it completely strips its citizens of their Second Amendment right. Furthermore, as mentioned before, a ferry is drastically different from typical sensitive places, and it should not be limited to that exact definition. In 2010, this court in McDonald versus the City of Chicago held that the right to keep and bear arms is enforceable against the states because it is a privilege recognized by and incorporated under the states under the 14th Amendment. Ms. Sommers has shown a real necessity for self-defense, and it would be unconstitutional to allow the Trevania State Criminal Code to infringe on her Second Amendment right. Your Honors, may I briefly conclude? For the foregoing reasons, this court should affirm the United States Court of Appeals of the 18th Circuit, which reversed the district court's judgment and hold that the Trevania State Criminal Code unconstitutionally restricted respondents' right to keep and bear arms. Thank you.
Thank you. Rebuttal?
Petitioner has 2 points on rebuttal. Respectfully to this court as well as my friend and adversary, respondent errs in her analysis of that Beniti case, which, by the way, was upheld and cited in at least three federal decisions. That case specifically held that the post office was a sensitive place because it's a government building, and the same should apply here. And second is just a general notion as to respondents' analysis about this crowded place. In this confined and highly sensitive vessel, it would require Navy SEALs training in order to effectively exercise Second Amendment rights without endangering the lives of potentially hundreds of innocent bystanders. This is simply a common sense policy. Therefore, petitioner requests the reversal of the decision of the Court of Appeals for the 18th Circuit. Thank you.
Counsel, you're not arguing, though, that the ferry is a government building, correct? You're still saying the ferry falls under subdivision E of the statute, correct?
Correct.
And yes, please answer.
But the property, including the station, does fit the category as a government building.
And to Chief Justice's point, paragraph E being argued by Ms. Schneider that it's not the entire statute that's overbroad, but just this particular provision. What say you?
Your Honors, typically methods of mass transit, are overcrowded and often occupied by police. And for those reasons, it is simply just unsafe to the general well-being of the public to permit firearm carry on these locations.
Didn't she feel, speaking to Ms. Somers, that it was unsafe at that moment? And hearing Ms. Schneider earlier say that, with the vast number of people that are on that ship, the difficulty for the number of officers that were present to assist her. Please speak to that.
The issue there is the location of the police presence when the event occurred. There was no one upon the exit. And quite frankly, Your Honor, and respectfully, I'd rather have 2 trained law enforcement officers potentially having to pull a trigger than potentially 100 law-abiding citizens pulling a trigger in this contained vessel where there's nowhere to go in the instance of an incident.
Thank you.
Thank you.
Thank you both. The court will adjourn at this time. Consult.
All rise.
All rise, please.
Be seated.
Before we announce the winner, we would like to thank the judges for taking the time to be here. This event would not have been possible without any of you, and on behalf of the entire Moot Court Honors Board and faculty, we thank you. Please give it up for our judges.
I'll take that one.
Sure. So I'll start out before I say anything. We were told we have to say who the winner is first, but I will tell you it was extremely difficult for the 3 of us in consultation sort of to determine who the winner was in this case. You both did a very, very good job. In a minute, we will tell you what we thought was really good, give you some critiquing, but overall, I think it's fair to say, and if you disagree, tell me, but you both did an awesome job, and most of the time we were going back and forth about who the winner is. So you both walk away winners from this. You both got to this final step, and but I think in this particular case, we have the winner as a respondent. So. With that said, I have to say you both did a great job. We obviously tried to frazzle both of you a little bit by asking some poignant questions, interrupting you, things that a hot bench will often do in these type of appellate cases. And I think we rattled you a little bit a couple times, but it was good. You came back at us and were very respectful in your responses, so I thought that was good. And then one of the things we were speaking about too was that you didn't get rattled as much, you know, and that you came back to your arguments. One particular thing of note for me was I told you I didn't want to hear anything more about argument 2, and you went back to it, and I was like, she's not listening to me. But then when you went back to it, you made an argument that I was like, oh yeah, I didn't think about that. So I sort of gave you you know, it was good the way you sort of just stayed on course there and all too. And I don't know, let me turn over to my colleague.
Well, I just have to say, you know, it's funny because, you know, we all know the jury system, and it was a very small jury, but we did deliberate, I have to tell you. I like the way you came out of the gate, and you were very strong. You make a great presentation, and you know you got the whole scene going. You started getting shots, you know, from the bow here. You know, you started getting questions, and I think you did your very best to stick to your argument. And frankly, it could be a hard argument. I mean, whether or not you personally believe in what you're arguing, but it looked like you did. And you'd come back to the argument, but you did take a couple of shots that threw you a little bit. But I mean, I have to commend you. It's a high pressure a time for any litigator to be up against you know, these 3 vicious judges. You know, but I thought you did a great job, and Schneider, I thought you did a phenomenal job as well. You know, before you went on, I was noticing, and I couldn't help but think, oh my gosh, she might be nervous. But when you got up there, I got to tell you, any of the butterflies you may have had, we didn't see them, and you were succinct. You made good eye contact also. You made good eye contact, and then you started getting the shots. And as Judge Crecca said, you would come right back to your issue and continue. So again, it was close, but we did deliberate. This wasn't, it was not a windfall. It was not a windfall. Okay.
Thank you, Judge. And I think for me, the key is using the attentive ear, is listening. When you practice, it's very important to understand your audience, and judges, they've already reviewed the case. They're aware, but there may be a little nuance there that interests them. And when he or she speaks to that nuance, your role is to speak to it strongly and to make sure that you have really answered that question thoroughly, because it can make the difference between winning and losing. In law school, it's the same thing. I attended Toro. It's going to the professors' offices and sitting down and listening to them and asking, how was your day? And allowing them to just talk about whatever is on their mind. Professor Hunt was very interested in contracts in the military. And don't you know that was on the final? And I wrote about that sword like you wouldn't believe, right? So it's all about listening for me. And I really felt that both of you listened well. I felt that you pivoted well based upon the questions. And I certainly appreciated how you were able to strongly go back to your argument and go forward.
And I think that's really good advice from my colleague. And it's not just for the two of you. I think it's for everybody in the room as a law student. And I was probably guilty of not doing this, of not listening, especially when I was younger. But as I've gotten older and more mature as an attorney and as a judge for the last 18 years, listening is so important. It's such an important skill as a lawyer. You've got to listen what's going on, because you've got to understand what that person's thinking, what that person's experienced and feeling on the other side, so that you can react both appropriately and also intelligently and persuasively. If you're not listening with a very active ear, you're not going to be able to do that. So it's crucially important. So I would say for all of you to do that too.
And you know, being on your feet, you might be able to more calmly, put an argument together sitting down and you have a pen and paper. But when you're up there, you're on your feet, perhaps akin to a surgeon who has to do quick decisions on his feet. I've never seen a surgeon operate or heard of a surgeon operate sitting down. So you think about another profession where you really got to think on your feet. So you're up there and all you have is your preparation in your mind, what you've written down, and you really don't want to look at it too much, right? So you want to have like key words that bring your mind to what you know. You don't want to start reading things, So thinking on your feet is a strategy, and then when you go into cross-examination, you don't know what this witness is going to start saying, and your mind is going to have to start going with this, all on your feet with your pad and what you have up here. And obviously practice makes you better and better, but I saw skills today that were very impressive. I really did, and that goes for both of you. And again, it was a close deliberation, I will tell you. All right?
Congratulations to both of you. You have our thanks, and this was fun. I don't know, are we done? Are we supposed to take questions? Or so?
That concludes our 40th annual John S. Bainbridge Moot Court competition. Congratulations to our finalists. Thank you, everyone, and thank you again to our judges. Have a good evening.